I'm Chris Dady, I'm Chairman of CPRE Norfolk, and I'm just going to give a very short introduction. But first of all, health and safety. I have checked it out, and it seems our route might be through that door, if there's a problem. Or behind you. It's behind you. If you've got a mobile telephone, could I ask you to put it on silent, please, or switch it off? And that's particularly because this is being recorded to go on to, and will be posted onto YouTube. So we'll put a link up on our website so you can access it later. So right, Helen, we'll put a link on our website to YouTube.
Oh yes, absolutely. Yes.
After each session there's a chance for questions, and then at the end there's another opportunity for questions. Now obviously we don't know everybody here, so it's always difficult to pitch the sessions. So we are starting off on a relatively basic level, but I think we'll get to hopefully the right level for everybody here during the afternoon. Thank you. So why is CPRE, why is the Campaign to Protect Rural England running this session? Well, the CPRE started in 1925 and was formed to campaign to bring town planning to the countryside. So that's where we started. Since then, we've campaigned and were successful in getting national parks, and in the 1950s we campaigned for green belts. So we have very much a planning base as far as the countryside is concerned. Our first session is being delivered by David Hook, who is the chairman of our planning group. So David, without further ado, and I'll wave at you when the time is getting near.
Thank you. Yeah, well, thank you all for coming along. I hope I haven't pitched this at too menial a level for your expertise, because I know a lot of you are parish councillors involved with planning, and so some of it will be stuff you already know. But if I start with basic principles, it will help maybe some of the people who watch on YouTube anyhow. First of all, that's the title of the talk, How to Oppose a Planning Application. The reason I talk about opposing planning applications is because most of the requests we get are from people who wish to oppose a planning application. We don't get an enormous number of requests of how to support a planning application, so I'm looking at it from the CPRE end. It would be nice if we could support more planning applications. Right, the title of this, don't worry about the title going up the top. The first thing you need to know when responding to a planning application is you've got to do your homework. You've got to know who you've got to address your objection or your support to. And that requires a knowledge of who is going to be determining the application. Who is the local planning authority that will decide on this application? Now in Norfolk it's pretty straightforward, because nearly all of our planning applications go to either the district council or the city council. They are the local planning authorities. But not exclusively, because, for instance, if you've got a school extension, in the days anyhow, at least when there were local authority schools, the application would be determined by the county council and not by the district council. The district council would just give a response in the same way that parish councils respond to things when the district council is determining the application. The other thing to mention really is that in Norfolk we do have a quasi-national park, the Broads Authority, and that does overlap with South Norfolk and Broadland, and they are a planning authority in their own right. So if you were in the certain part of Loddon, which is in South Norfolk but also in the Broads Authority area, you need to check whether you know the precise location of the site and work out whether it should go to your opposition should go to the Broads Authority or to South Norfolk. Sounds fairly silly, but you do need to know the application reference number and make a careful note of the date that you can respond by, because if you miss that date, some authorities are a little bit liberal with it, but your views, in some cases, you'll lose the chance to have your views listened to. Now this is the difficult bit, the paperwork. If you put the application reference number into the internet on the council website, very nice and straightforward on South Norfolk, you just put the application number in, you'll get a link to the application, and you'll be able to view all the documents that have been received to that date and have been put on the site. Most people these days are familiar with the internet and can do that. Now the paperwork can be a confusing collection of things. It will include the plans, the application form will be there, there'll be comments from statutory consultees, Highways Authority. If the Environment Agency needs to comment, they'll comment. There'll be design and access statements, there'll be letters of support if there are any, letters of objection if there are any. It may also, if it's a big application, include an environmental impact assessment. Now, if you try and read all of that in one go, you'll end up with a scrambled mind and you'll wonder what the heck to do next. It's best to have that accessible and to dip into it as and when you need to in the preparation of your objection. If you're not internet savvy, you can make an appointment to go and see the planning officer overseeing the case, and you can view the documents in the council offices, and South Norfolk in particular are very good at allowing people to do that. I haven't got so much experience of other local councils, but I'm sure they would facilitate that. And if you're prepared to pay the photocopying fee, they will probably make copies of the documents for you to take away. Sometimes it's better to look at a hard copy of a plan than to look at a copy on the screen. But increasingly, everything's coming through the wires. I mean, as a parish council, I'm chairman of a local parish council, we don't get hard copies of plans anymore. We get them through the internet, and we display them at parish council meetings on the wall. Now, not the best way to do things, but I can understand the costs and the paperwork implications of always providing hard copies. Right, a very important thing to do is check the planning history of the site. There may have been an application on that site for something similar in the past. Now, whatever the decision was on that application is going to guide you now. If it's been turned down, the same kind of application over and over again, that's going to give you quite a lot of information that you can use in your own writing of your own objection. This seems obvious. Visit the site. Well, most people, when they object to a site, it's close to them, they live next to it, they've been there many times, they know the ins and outs of it. But sometimes if you go to a site with the application and the plans in your mind, you can pay more careful attention to the things you need to look for. And one of the key things you need to look out for is how will that development fit onto that site, and how will it blend or not blend with its immediate surroundings. Now, increasingly I've found in planning applications, sometimes not blending is considered, and conservation officers do this, and it's considered a good thing. They kind of say, well, it's introducing a new element, it's an eclectic mix of things, and I've seen that increasingly coming in. We had one in our own village recently of a 50s bungalow bought by a northern architect, and he wanted to put a box of bedrooms on the top. And it was an old slanted roof with a box on top. It looked extremely interesting. It was in a conservation area, and it hasn't, well, it's still awaiting whether it's got approval or not, but the conservation officer actually looked on it quite favourably, whereas those of us of a more conservative with a small c background thought it didn't fit the conservation area. So fitting into its immediate surroundings can be a complicated thing. Other things to look at, is the application form accurate? Have all the bits been filled in? Because obviously if there's an error in the application, that's something you can use in your opposition. And it's amazing how often there are errors in application forms. what effect is it going to have on the local area, particularly the road system? Now, the Highways Authority will make their comments, and if they say it's going to be okay in terms of the impact on the roads, that's probably enough for the Planning Authority that's probably all they need. But you with your local area can know things sometimes that a Highways Authority does not know, and that can be very beneficial. Is it going to lead to? Is it likely to lead to further development? Is it the first of 10 houses and then the next lot will be another 30 or 40 or 50 houses? Is there going to be a cumulative development, a cumulative effect from the application? Are there lots of other things in the area similar to that one that this is going to add to? This is particularly relevant when it comes to wind turbine applications. If there's already a lot of wind turbines in the area and there's an application for a new site, then this is the kind of application that brings in cumulative effect. Although, of course, with government subsidies for wind, onshore wind disappearing, wind turbine applications have become very rare indeed. Ask yourself, does it meet local needs? If it addresses local needs, then it's harder to oppose. If it's contradicting local needs, then it's easier to oppose. And finally, I've put, is it on a brownfield site? We're very keen to encourage development on brownfield, not greenfield sites. Go to the next slide. Prepare your objection. Well, this kind of runs into writing your letter of objection, so the 2 pages go together. It's very important that you don't put things in when you're thinking about your objection. You mustn't say things like, it spoils my view. You mustn't say things like, it will lower the value of my property. You can say it contradicts policy plan, blah, 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 protection from development in the open countryside, but what you're really thinking is, it's spoiling my view. But you've got to find a policy to back up what you say. And the most important thing is you've got to concentrate on material considerations. And I'm sure Christopher Kemp, who's a very experienced member of the Development Management Committee at South Norfolk, I'm sure he will point out a lot more about material considerations, the kind of things that can come into play and the things that do not come into play. Now, this is really part of your homework, because you need to go into the planning policies that are relevant to the application. And starting at the top, it's in a hierarchical form now. At the top is government planning policy, the National Planning Policy Framework. It's actually an easy to read document, although there's a lot of paragraphs in it. And what you're looking for, if you're trying to oppose an application, you're trying to look for ways in which the application contradicts what's in the policy. Now, I'm going to just give an example here, because my expertise mainly is in fighting against light pollution. And so I'm going to envisage a situation where in my village someone's put in an application for a floodlit golf driving range. And I want to write a letter of objection to that application. So I'm going to look at the National Planning Policy Framework first, and I'm going to try and find the clause that I can use to have a go at this application. Well, I know this one because I've used it many times. It's National Planning Policy Framework, paragraph 125. A local authority, by encouraging good design, should have planning policies and make decisions that limit the impact of light pollution from artificial light on local amenity, intrinsically dark landscapes and nature conservation. So I can immediately quote this policy, say that this floodlit golf driving range will contradict the aims of this policy, etc., etc. Then I'm going to look, assuming it was in my village, which is in South Norfolk, I'm going to look at things like the Joint Course Strategy, because South Norfolk, Broadland and Norwich produced a strategic plan, the Joint Course Strategy, which may mention protection of the environment, etc., etc., and it does indeed. But most importantly, I'm going to look at the development management policies of the local planning authority, South Norfolk Council. And I'm going to see what they've got to say on it. And I find that their Development Management Policy 3.13 says very good things about maintaining privacy and restricting artificial light pollution, protecting dark skies, and it also says how valuable dark skies are in the countryside. So I'm really pleased to see that in Development Management Policy 3.13. That's a very, very good piece of policy from South Norfolk. And I'm also going to see that and be aware of the fact that with something like a golf driving range, it could be conditioned and it could be curfewed only to be lit at certain times. So I need to sort of think about that, because the applicant will probably say, well, yes, it does have a major impact, but it's only on 2 hours on a Thursday and a Friday, and that could affect the decision. So I can find the policies relevant to that application, but of course, when you're looking at an application, say for housing, there are lots and lots of policies at NPPF level, at local authority level, and even down lower levels at neighbourhood plans and parish council level. And you need to study all of that, and you need to dig out the ones that you can quote from. And I'm sure if you're in a parish council, you've already done this, but I can't go into too much detail on it because of the time, but I can't stress over much how important it is that policies are looked at and policies are quoted, and that contradictions to policies go into the objection. Because a policy-based objection will hit home. An objection which doesn't root itself in policy will have little chance of success. If you can't find anything that in the application that contradicts a policy, your chances of succeeding with an objection are extremely limited. Just a point, I mentioned development management committees. That's the new name for planning committees. I think all the local authorities now have development management rather than planning committees. Other things to check out for is the development in a conservation area or an area of outstanding natural beauty. This could give you more power to your elbow in fighting the application, because clearly there will be even an additional amount of paperwork and policies relating to conservation areas and areas of outstanding natural beauty. Will it affect a listed building? Is it in fact an application for work on a listed building? This is also another thing to take into account. Is it close to a site of special scientific interest or a nature reserve? Will it have an impact on trees and hedgerows? Are there tree preservation laws? So?
You said, is it close to? How
yeah,
close
it doesn't
is
have to
close?
be on an SSSI. I mean, for instance, if you had an SSI which was important for frogs and newts and many other animals, or bats, and you wanted a golf driving range and you put up floodlights, well, they'd have a major impact on bats. So actually, the golf driving range wouldn't need to be on the SSSI for the SSSI to be relevant. So. It all depends on the individual circumstances, which brings me back to my first key point, is look at the site and look at the surroundings, and be very clear about how the application fits the site and the surroundings. One thing I would advise you to do, and planning officers, they're very busy people, they do an awful lot of work, their workload is always increasing, but the case officer for an application, in my experience, is usually really, really helpful, and fortunately still accessible on the telephone without going round the automatic answering system. And I found with South Norfolk in particular, very, very helpful assistance from case planning officers. If in doubt, ring them up. They will help you out. They won't necessarily agree with the stance you're taking, but they will give you assistance as to how to navigate your way through it all. So the next slide is writing a letter of objection. Well, let's just carry forward, your preparation into the letter. Be clear and courteous. Don't go on whinging about the farmer who wants to put a load of houses on their land and how they're rich enough already. You may think that, and it may be true, but don't go on about that. Be courteous. You don't need to get personal in any of it. Be very clear in what you're trying to say and concentrate on the facts. Straightforwardly concentrate on the facts. As I've said, and I reinforce this now, list the planning policies or bits of the policies and state quite clearly how the application, if you can find conflicts with the policies, this is where you put it in. Name the policies, name how it conflicts with them, write that out clearly, and that's one of the strongest ways you'll get your view across. Explain also how in your opinion, how the development could have a negative impact on the local community. If it only affects one person, yourself, then your chances are, well, you may have a very legitimate objection, of course, but I mean, if you can show that it has a wider impact than just on one person, i.e. on the community, this will reinforce your case. Put in all the bits about impact on listed buildings, SSSIs, wildlife, etc., if they're relevant. If they're relevant, don't just load a load of stuff in there that isn't applicable to that site. Only if it's relevant, put it in. Point out quite clearly any inaccuracies in the application, because if the application form is not filled in correctly, that might be enough on its own for you to achieve your objective of having the application refused. And also consider a fallback position. If it's approved, can you suggest some conditions or a condition that will reduce the impact on yourself or on your village, and maybe even suggest some wording on the condition? And again, the planning case officer might be able to help you out here. For instance, with my floodlit golf driving range, I may sort of suggest a condition, A, that the lighting is full cut-off flat glass pointing downwards only, it's only switched on when the golf driving range is needed, it's curfewed to two or three evenings a week, it's only on for 1 or 2 hours. That way, I'm not going to be looking at whopping great floodlights into the sky, dusk to dawn, seven nights a week. So consider a fallback condition, and it doesn't mean to say putting in the idea that that conditions are acceptable to you won't necessarily weaken your objective. Although maybe having prepared a condition, you could present it. Possibly you could present it on the day of the hearing. Actually, I'm not sure about that. Chris will dot the I's and cross the T's and say the kind of things that a development management committee would find acceptable when the application's in front of them. And finally, get your letter in on time. Otherwise, it's the greatest letter in the world will have no impact at all. One thing I would say, and Christopher again will tell you whether you've got a right to speak at a meeting as an individual. As a parish council, parish councils can usually get a 5 or 10 minute slot, depending upon the size of the application, to put their point of view across at the meeting when the application is heard. But as an individual, you probably don't have an automatic right to speak at the meeting. But if you contact the planning officer, speak to the right people and say you'd like to say your bit at the meeting, most of the time, as long as they haven't got too much business on the day, your request is likely to be granted. Bear in mind, of course, that not all planning applications are determined by the Development Management Committee. Increasingly, a large number of applications are delegated for officer decisions. And however, if it's a biggish application, a significant application, if there are lots of objections, it's going to go to the Development Management Committee, and therefore you can have your say. That's another reason why you need to get letters of objection in order that it goes before the Development Management Committee. Because the planning officer will make a recommendation to that committee, either to approve or refuse or approve with conditions. And usually the Development Management Committee, not always, but in the majority of cases, they will go with their officer's recommendation, because that's why they have planning officers, to advise them on this kind of thing. Chris, again, will probably be able to give some notable exceptions where the Development Management Committee has actually gone against the advice of the officer. Right, and final page, enlist support. If it's a big application and a lot of people oppose it, you may be able to get your MP on side and to come along and speak at the meeting. Certainly your district or city councillor should be approached. They can speak at Development Management Committee meetings, your ward councillor. Your county councillor, they may be the same person as the district councillor, they are in our case in Hemphill. They could maybe offer support. Your parish council or your town council, they could object to the application comes before them, they have a right to approve or recommend approval. They're not the local planning authority, they don't determine the application, but they can request approval or refusal or approval with conditions. And if it's a big application, neighbouring parish councils could be asked for their view. If you can get parish councils on side, they can speak at meetings and it can reinforce your case. Ask CPRE for help, but please, we cannot respond to every single application that comes in front of us. There are far too many, so we tend to only get involved in the big strategic issues. However, you can go on our website and look at our planning policy guidelines. And if, for instance, on the lighting one, we've got comprehensive guidelines on lighting. You can quote anything from us, from our policy guidelines, as long as you quote us accurately and not selectively, and don't distort what we say. But that's a way of using our policies to benefit yourself without us having to write individual objections to every application. Ask if it concerns ecological issues, try and speak to Norfolk Wildlife Trust or English Nature or Natural England and see what they've got to say on it. Involve conservation societies if it's going to have an impact on your church or a historic building. Get your neighbours to write letters of objections. One letter of objection is going to be less significant than 100 letters of objection. And if it's a huge application, form an action group. Get a lot of people on your side. You can then hire planning lawyers. You can then do the whole business. I mean, in Hampton we had a big one with the wind turbine application. We had a planning lawyer. The community spent £50,000-60,000 objecting to that application. That's the kind of clout you get if you can get an action group going. And although it didn't affect the officer's recommendation, I think it had a big impact on the Secretary of State when he finally made his decision on the issue, because politicians are concerned about mass movements and will help you out, especially if it's just before an election. Now, Christopher will explain the rules for lobbying other councillors on the local planning authority development management committees. Used to be that if you tried to contact them in advance of a meeting, they couldn't be predetermined, and it meant it was a very limited thing you could do there. But that has changed, and I'm sure Chris will enlighten us on how much lobbying you can do of the development management committee. And finally, just the final whiz, and then don't give up, because unfortunately, even if the local planning application sees it your way and agrees to refuse the application, this may not be the end of the matter. The applicant can ask to go to appeal. There might be a planning inquiry. It might be decided ultimately by a planning inspector. It may be you may be able to get it called in for determination by the Secretary of State if it's a big one. And even if you win at the planning inspectorate stage, the planning inquiry, it could still go to a judicial review. And unfortunately, although we're trying to change this at CPRE, if the original application is approved by the local planning authority, unfortunately as a third party, whether you're a parish council or an individual, you sadly do not have a right of appeal. You can't take it to the planning inspector, but the applicant can. Whiz through that, and I hope it hasn't been too basic for you, but I've gone over a little bit, haven't I, Chris?
Can I
we
just say
stopped
one little
there,
thing on your very last point, David, on this third party right of appeal? There is actually currently an online petition on YouGov about parish councils being able to have the right of appeal. So I'll try to remember to send you all the link if you haven't already seen that as well.
And we've got free copies of these booklets that you can take how to respond to planning applications. They're not bang up to date, they predate the MPPF, although it's referred to in it, but they are very useful in many ways.
Don't run off. We've got a couple of minutes for... Are there any burning questions for David? There will be questions at the end, so I'll try and bring us back in time, but if there's a couple of burning questions, we'll take them now. Sir?
Our village, 200 new houses, has already gone through all of this process. It's been solidly rejected by North Norfolk District Council. We're waiting to see if there's going to be an appeal. Will you be giving us advice on how we as villagers or an action group we have would approach the appeal.
You have sitting immediately behind you Ian in Shepherd, who is our North Norfolk expert, well, an expert in many ways, not just about North Norfolk. So at some point, have
There is a tea break, so have a chat in the tea break.
Yeah.
Okay.
The problem is, of course, even if the district council rejects the application, there are so many loopholes. And Ian and I were at a seminar the other day when we talked with the planning policy manager at North Norfolk District Council, and he explained how even with the 5-year land supply, when a local authority thinks it's got its 5-year land supply in place, how developers can actually manipulate that in such a way that the local authority never gets to its 5-year land supply, and therefore they can keep asking for more and more and more. But have a word with Ian, and because
We know each other.
you
that's
know
fine.
each other, yeah.
David, there's another question.
Just
there.
one very quick question. Do county wildlife sites carry any impetus? You talked about triple SIs, but do county wildlife sites have?
County they are, whether it's an SSSI or a county wildlife site, if there's an impact on the site, then that is, I think I'm right in saying that is a material consideration that the planning authority would take into account. Obviously, this is where if you can get an expert who knows about wildlife and can detail the impact, that will add meat to the case. That would reinforce the case.
Yeah, I'd just like to say,
Okay.
I work for Norfolk Wildlife Trust, and we comment on all planning applications that may impact a county wildlife sites. And if you have any questions, do get in touch with Norfolk Wildlife Trust. It's a free service as well. So.
And final question.
Okay. Changes in the planning legislation. How do you see the effect of such as the 200 house application? The new legislation looks as though it's going to reduce the time you have to object to something. How do you see that new legislation?
Yeah, I did print it out. The Housing and Planning Bill reached the committee stage in the House of Lords in March 2016, and I haven't had a chance to absorb all of that, but it seems to me that it's in line with the government's belief that planning is something which gets in the way of the things that we should be doing, rather than planning being a blithering wonderful thing that's protected high density populated Britain from some terrible things over the last 50 years. It's considered to be a problem, and this seems to be trying to simplify things, reduce consultation, say that consultation doesn't have to happen at every stage to speed things up. Changes, forever changes, and unfortunately from a CPRE point of view, they seem to be going in the wrong direction, and I'm sure lots of you would concur with that. I can only say that this looks quite frightening in terms of its content. I mean, it's available on the NALC website, isn't it, if you want to study the...
It is. I printed it off.
You've got it as well.
Yes.
Yeah, it's, I haven't quite got my head around it, but it's certainly moving in the wrong direction.
Okay, well, thank you, David. Our next session is, and I shall invite Councillor Kemp. Can you join me? Councillor Kemp is a member of the, as David said, the Development Management Committee of South Norfolk District Council. Used to be the Planning Committee. I think it still has the same function-ish. And Chris was going to talk about how a Development Management Committee deals with planning implications.
Good afternoon. I think the first thing I should explain to you is why we call our committee the Development Management Committee, because we've had a committee called the Planning Committee for many years, and a suggestion was made about 4 years ago that we change the name of it to the Development Control Committee. And I said that's ridiculous. We delude ourselves into believing that we can control anything. You can't control the market. All you can do is regulate it and nudge the edges of it. And this is why we call it development management, because there's never seemed to me to be any purpose in deluding yourselves and then deluding other people in the process. So we are a development management committee. I wish we only had 200 house applications to deal with. We recently rejected an application for 650 houses in my own ward, and we had good and substantial reasons, but they were overturned on appeal. I represent Cringleford Ward, and that is doubling the size of Roundhouse Park, and the village will be 5 times larger at the end of the 2020s decade. But then many villages will be, and that is the issue that we have to address in many ways, because the system is oriented to granting permission. It's always a case of whether you should refuse permission, not whether you should grant permission. That's always the way round that it tends to operate in practice. Now, the next slide. Unfortunately for you, as well as being a member of the Planning Committee, I am a retired lawyer with a great interest in political philosophy and history. Indeed, I'm writing a book, and that's what my doctorate is in. And I always like to start any talk I give with a quotation, and this one it's very relevant, because as the CPRE, I've no doubt you could wax lyrical about the countryside and philosophical issues of that nature. But what we as a planning committee have to administer is the law. We do not make up the rules as we go along. We have to apply the rules that are laid down by Parliament or under the authority of Parliament. We are only there because Parliament allows us to do this. We have to be thankful that we have this process. Think back 1,000 years. Who gave William the Conqueror planning permission to build Norwich Castle? Things have moved on a lot since then. All the people who objected were killed, of course. So things have moved on a lot, and we have to be thankful that at least there is a process of consultation, there is a process of democratic representation. I only make these decisions because the people in my ward elected me to do so. And all of us who are actually serving on the committees are elected to do so by a process that we submit ourselves to every 4 years. Right, let's have some basic principles. I'm sorry this is a bit faint. You need a room with proper blackout curtains.
I know, it's terrible.
The world is not, I think that's one of the essential points about what we're talking about today. The world is not ideal. You can try and make it a little less unideal, if that's the right word, but you cannot make the world ideal, because it never will be, because it's full of human beings and other things as well, which cause a problem. Okay, so we have to, as a planning committee, whether we call ourselves development management or whatever, we have to by the way, at county it's called the Planning Regulatory Committee, and they still have functions in relation not only to education but very importantly to waste disposal sites and to mineral winning, gravel, and those are matters which are dealt with at county level, not at district level. Everything else is dealt at district level. We have to consider a planning application in accordance with English law, which includes European law, in particular the European Convention on Human Rights, which is now in force under English law, not because it's a convention that we signed up to in 1948, but because the Human Rights Act 1998 gives it the same force as an Act of Parliament in this country. I think it's important to understand we are not judges, we are not performing a judicial function, but we have to act in what is termed a quasi-judicial manner. That means to say, as has been suggested previously, we mustn't be predetermined. We must have made up our minds before we hear the case at the planning committee meeting. We have to consider the evidence that's presented to us, consider the representations that are made, consider the advice that the officers give us, and then reach a decision. And we must always act in a rational and objective manner on an evidence basis. These are phrases which have been endorsed by the courts over the years, going back in some cases into the 18th century, these concepts of a rational and objective decision which is on an evidential basis. As a result of it being required to be exercised in the quasi-judicial manner, if, for example, a member is sitting on the planning committee dealing with an application that is on a piece of land that adjoins a piece of land that he owns. He has a pecuniary interest and he has to declare that interest and leave the meeting and not take any part in the meeting. When our district council makes a planning application on its own land, the members of the district council cabinet, of which I am not a member, have to leave the meeting, who happen to be members of the planning committee, likewise have to leave and take no part. There used to be a different way of defining these interests. They are now confined to just pecuniary interests and non-pecuniary interests, which can come from closeness of relationship. So if it's owned by your wife or your husband or your cohabitee or whatever, that is your interest as well. Members have to complete an annual declaration of what companies they own shares in and all those sorts of factors, so all of this information is on a public register to be inspected, and each council has a slightly different way of doing it, but the basic rules are the same. If you wish to make representations to a councillor who is a member of the committee, then be aware he has to disclose that he has been lobbied. That's the word, lobbied. If you have been lobbied, it does not prevent you from taking part in the discussion, but it merely means that you have to disclose that you have had an argument put to you. And so if you write to your councillor, if you speak to him at a parish council meeting, as often is the case. I have two parish council meetings this week and I expect to be lobbied on planning issues at both of them. You have to just say, I have been lobbied by objectors. I appreciate it's been explained to you about oppose, but in fact, as far as planning protocol is concerned, you either object or you support or you're neutral. Planning, parish councils sometimes get this wrong. It's not necessary for them to recommend refusal or for them to recommend approval. What they should do is either pass no comment or object. Anything else actually opens them to certain risks. And this is advice that is consistently given to parish councillors and in particular their clerks, who should be giving advice when this comes up to make sure that it's handled correctly. Now, as I've said, this is an evidence-based process, and though it may well give you a feeling of, well, I almost said of the herd instinct, if 1,000 of you write and with the same objection, that carries no more weight than one well-reasoned letter in support, because the principle is witnesses are weighed, not counted. That's an old law, legal principle going back to 2.5 millennia, to the Roman era, and there is a version of it in Latin which I won't trouble you with. But that's the rule. Witnesses are weighed, not counted. It is the quality of the evidence, not the quantity of the evidence, that counts. So if 10 people make the same point, that carries the same weight as one person making a different point. If it's a well-argued case, that's what counts. Is it well argued? Is it based on material considerations? Is it based on fact rather than speculation? We have to be even-handed, which is why when it comes to the meetings of the committee, the rule is that the objectors collectively have 5 minutes. That's our council. Some councils have different ways of doing it. Some have only 3 minutes, some have 10 minutes. Our rule is normally 5 minutes for the objectors, 5 minutes for the applicant, 5 minutes for the parish council. The local member, that's the member who represents the ward that is where the application is occurring, he or she has 5 minutes as well. then it is decided by the committee. The committee are allowed to ask questions to the objectors, the parish council and the applicant, but they cannot ask questions of the local member. The objectors cannot ask questions directly of the applicant and vice versa. The process is directed to the members of the committee who are making the decision. Next slide. We're making a value judgment, and we're elected to make that value judgment by the community. Because the general election was on the same day as the local election when I was re-elected in 2015, 44% of the people of my ward actually voted for me, which is almost half, and which is quite unusual to get that degree of support. And I've been their councillor since 2003, and a number of people there know me quite well, so I can say that they want me to do this job on their behalf. I am, as it were, anchored in the community by that democratic process, and we're accountable to the people, and we have to work within the system. We don't create the system, Parliament creates the system. Technically speaking, the planning system and the planning committee and the process by which planning applications are determined are creatures of statute. They are created by Act of Parliament. And there's only one rule about Act of Parliament that is of lasting significance, which is Parliament cannot bind itself. So Parliament can decide at 12 o'clock on one day that the law will be X, and it can decide 1 minute later that it will be Y. And that it cannot prevent itself from having that opportunity to change. That is why, to me, the day of the general election is a very special day, because that is the day when the power returns to you. It returns to the people, and the people decide what is going to happen over the next course of Parliament. It's one of my fundamental beliefs, and one of the reasons why I'm an active member in local government is because I believe that the political system only works if there are a choice, and that choice has to be provided through political parties, and democracy will not work without a choice being guaranteed in some shape or form. Now, members are trained to do this work on planning. It's more than just being elected. You have to have accreditation. We have probably 6 sessions a year of 2 hours, which you must attend at least one session a year to sit on the planning committee or the development management committee, so that you know actually what you're doing. We have one coming up in the week after next. It's dealing with a topic which is quite an interesting one, because there's been a recent change in the law whereby, you've probably heard of Section 106 agreements. They often have in them a provision for affordable housing, and developers are allowed to come back and say, can you relieve me of the obligation to build 33 1/3 and reduce it to 20% or whatever. And that is dealt with now under an accelerated process under Section 106AB. When you insert an additional section in an Act of Parliament, it gets quite complicated with the way that they don't renumber it, they give it a new number in an internal sequence. And that's what our training is about, how to deal with Section 106AB applications, because they cause a great deal of controversy actually when people have perhaps with reluctance accepted 20 houses in their village on the understanding that 6 or 7 of them will be available for local affordable needs housing, and then when the developer says I can't afford to go ahead with the development without reducing that from 7 to 4 or something of that sort, people get quite unhappy about it. But you have to live in the real world, and in the real world people only build houses because they'll make a profit by selling them. That is the reality of the situation. Developers like to build up banks of planning permissions. That's one of the ludicrous aspects of the 5-year land supply situation. That's all it's doing, is building up banks of planning permission that they hang on to until the market improves and they can sell them for the over inflated price they bought them for in the first place. But that is the system. We have to make the best of the system for you and for those who we represent. We are not at a level within this hierarchy where we can change the system, though we can make representations to our colleagues. As well as that training that we undergo, we also bring to our work as members of the planning committee, and indeed as the other duties that we perform as councillors, our life and career experience. I'm a retired solicitor. I have a doctorate from the UEA in the School of History, and I was first elected a councillor at the age of 25. I've been a councillor on and off now for 48 years. I've been on the South Norfolk District Planning Committee and now the Development Management Committee since 2009. But that's not all I do as a councillor. I'm also a member of the Police and Crime Panel. I'm the chairman of the Norfolk Records Committee. I'm on the Regional Joint Council that does the negotiations with the trade unions on behalf of employers. So we're not very narrow in our specialisms. We work in all the areas where we've got life experience or qualities or background that helps us. And as has been pointed out by the first speaker, we have the benefit of the advice and guidance of planning officers. We have to give high regard to their advice, but ultimately the decision is for the member. We are required by the government to delegate as many planning applications to officers as we possibly can. There used to be a grant that was available to augment local government finance that was based on achieving a target of 80% delegation. And in South Norfolk we have about a 92% level of delegation. And every month at our meetings we get a report on the appeals that have been lodged and the outcomes of the appeals, where the appeal has been against what the officers decided under delegated authority. And we have about 9 out of 10 appeals rejected, showing that the officers are correctly applying the local policies, are correctly applying the law, are correctly applying the government guidelines. Every meeting of the planning committee, I take with me my copy of the joint core strategy. I take this with me, which is the use classes guide. It's not realised, for example, that you can convert a building from one use to another without getting planning permission if it is within the broad definitions in the use classes guide. I have with me my copy of the National Planning Policy Framework and the guidance that goes with it. On the question of your interest in a green belt round Norwich, we have here the landscape document prepared in connection with the landscape protection zone around the southern bypass, which is part of South Norfolk's policies. This is our summary of the development management policies. We've had government guidance recently on 106 affordable housing. This is the important one, as Mr. Hook has pointed out, the National Policy Planning Framework. As a lawyer, I'm very interested in this because most of it is capable of 5 or 6 different interpretations. At the moment, I'm not paid to put a particular one forward, so I can use my judgment. New houses have to comply with the Building for Life. This is 12 criteria. We now have red, amber and green colours on these. We recently rejected on South Norfolk a planning application for a small development in a village where the original version had got 5 reds and 7 ambers. We rejected that even when it came forward with 9 greens and 3 ambers because it was still badly designed. And that is one of the reasons why we can reject. And as a member for Cringleford, I'm very proud of this document. This is the Cringleford Neighbourhood Development Plan. The first neighbourhood development plan to be adopted anywhere in the country, the most comprehensive one, and unfortunately the one that is being disregarded most, because this doesn't apply if you do not have a 5-year land supply. That is the big problem. And I understand that the government are looking at this because they feel that they've been persuaded that the 5-year land supply is a blunt instrument that's not working properly, but how it's going to be refined, who knows? I too am concerned about the housing and planning bill. I subscribe to a service whereby Parliament sends you every week the latest editions of Acts of Parliament, and you can see the changes. And I think that's a very useful thing to do. And I use it for other areas of interest. There's an act going through that's going to change the relationship between the police commissioner, the chief constable and the police and crime panel in relation to the supervision of complaints against the police. That is something that I deal with as part of my duties on the panel. So you need to keep in touch with these things. I'd like to now go on to material planning considerations. We have to have high regard to what a material planning considerations, which is I think it's section 39 of the Planning and Compulsory Purchase Act 2004. I actually have a note of this in here. Let me get that absolutely right. Yes, the Planning and Compulsory Purchase Act 2004. Well, this is also very interesting because this act gives the Minister power to issue guidance. And that's what the MPPF is, guidance. But we must have regard to guidance. That's a slight contradiction, isn't it? It's another form of delegated legislation, but it's not subject to the statutory instrument rules. Very interesting. It's been going on since Henry VIII, but I won't go into the history of it. We have to strike a balance between material considerations. Environmental impact is very important, visual amenity is very important, conformity to the pattern of the area is very important. I think you as a CPRE will be very interested in our placemaking guide in South Norfolk. We have a placemaking guide which has identified, I think it's 26 sub-areas in South Norfolk district. And we have identified the vernacular style in that particular area. So there are parts of South Norfolk where most houses do not have porches. So we do not allow new houses to be built in those areas with porches because they will literally stick out like a sore thumb. But there are other areas where the houses mostly do have porches. That's just a fairly superficial example. But we have identified in this book, which is available as an interactive PDF and is widely used by developers to give guidance so that design is improved. And by and large, design has, in the 6-7 years I've been on the planning committee, and it's now the development management committee, the quality of design has improved. We get a lot of applications for designs in the open countryside where it has to be outstanding and innovative, and very often it's quite difficult to be innovative and outstanding, and architects get quite angry with us when we reject some of these applications. But what is outstanding to somebody is not always outstanding to everyone, and of course it is ultimately a value judgment. And as I said before, we are elected to make value judgments on behalf of the community we represent. So objections should be directed to material consideration and to the weight that members should give to those, because it's a balance. We have to weigh up in the balance X and Y pushing in one direction and A and B pushing in another direction. Now, I often, in my mind, will come to a conclusion when I say this case is 55 one way, 45 the other way. Some people find that unhelpful. I've always found that a helpful way of analysing things, because as a lawyer I was used to the fact that in the criminal court you have to be 99% certain of someone's guilt, but in the civil court you only have to be certain on the balance of probabilities, which is 51%. So I always, and very often officers will say, give a recommendation on a 55-45, and we will come back as members the other way round. And officers find that acceptable. It's when the thing is overwhelming in one direction and members ignore that and go the other way that problems are caused. Can I make a very important point? When you are speaking at the committee, do not try and increase your... try to keep emotion out of it. Emotion is unhelpful if it is not used in support of rational argument. That is the definition of, after all, of rhetoric, which is the use of emotion in the support of reason. The decision that we have to make is a one based on reason and reason alone, and that means applying the law. Sometimes people shout. They use language which is really quite inappropriate. They make implications about the personal conduct of councillors and of officers which are wholly unacceptable, because they feel so strongly about it that they actually miss the point that they're trying to put across. And I think it's very important that you avoid that, because that only makes members, erects a barrier to members giving a full hearing to the proper element of your case. Almost there. So we have to consult with various statutory bodies, and those include, as it says on here, Highways England, Heritage England, that used to be the Highways Agency and English Heritage, Sport England, the NHS, which is very important with new housing developments. Is there going to be enough provision of doctors for the new development? And the Environment Agency, Parish and Town Councils, and we also have to consult with Anglian Water, who usually are, to be quite blunt, useless. They give you no answer, or they give you such a vague answer that it doesn't help at all. We have had too many cases where particularly Sport England just deal with it as a desk exercise and don't actually come and look at the site. We had one case where they said that we do not want you to give permission to this sports ground to have a single 20-metre high wind turbine because it will interfere with it will cause difficulty for the batsman on the cricket square. And fortunately, or unfortunately for them, I'm a retired cricket umpire, and I worked out that this shadow from this would only affect one end of the square, if you understand what I'm talking about in terms of cricket. It would only affect one end of the square if it was a left arm round the wicket bowler, and we therefore felt that that was not worth the paper it was written on, and there'd been a pure paper tabletop exercise. And this is very often the problem that you get. Can I also make the point, do not expend all your energy on getting the parish council to take a certain view. That energy should be directed to the members at the meeting. The parish council have a view, but it's the members who make the decision. And finally, a few practical tips. You can weaken your case by the way that you present it. Remember what Nicholas Parsons says at the beginning of Just a Minute. No repetition, no deviation. Those are the two key rules that you need to remember to make the best use of your representation time at committee, and indeed in writing your letters. No repetition. Make your point once strongly. No deviation. Only make points that are relevant to the application and are based on material planning considerations. Mr. Hook has covered this very well in his earlier remarks. do not insult the committee or the members. We had a recent case where a representation implied that as the members of the committee had received bribes, this meant that we had to adjourn the meeting to investigate the application and wasted 2 hours, whereas if the person had merely guarded their tongue, this would not have happened. And I personally regard it as a great insult to have this suggestion made to me. If anybody is stupid enough to give me a brown envelope, I will go and hand it immediately to the police, together with a full statement as to the circumstances in which it arose. Because, you know, as far as I'm concerned, I was a practicing solicitor for 45 years and never had a complaint against me, let alone one sustained, and I have no intention of changing my way of life in that regard. Now I'm retired. We can only comply with the law, reflect on material planning considerations. It does nothing to strengthen your case by shouting, by waving banners. It's the words, not the way in which the words come over, that counts. And that's very, very important. As I said before, rhetoric is the use of emotion in support of reason. That's again a quotation from Cicero, by the way. And this is the way I'd sum this up. If you behave reasonably, your arguments will get reasonable consideration, and that's what you're entitled to, and that's what we as members seek to give you. And there's another point that I make in that regard. Sometimes we have a meeting that starts at 9 o'clock in the morning and goes on till 7 or 8 in the evening, and I get very concerned late in the afternoon and onwards, whether people are getting a fair hearing compared with those who are dealt with at the beginning of the meeting. Judges only sit in court from 10 till 4:30 with an hour for lunch. They don't do that because they're lazy. They do that because they know, experience tells them, academic research tells them, that there's a limit to human concentration, even the most intelligent people. And the same applies to counsellors. And the same indeed applies in the way that you put your case forward. This is, in a sense, it's a cooperative thing. We will reciprocate to you using the system properly. But if you are in some way trying to get an advantage out of the system that's not there to be got, then you will get rebuffed. But we don't want to do that. We want to balance the considerations and give everybody a fair hearing. Any questions? I'll be happy to try and answer them.
Thank you, yes. So having given such a careful consideration to reasonable and being considered, why do you sit for 7 or 8, 9 hours?
Because we have 40 cases to deal with.
Do it over 2 days? It's
Because
not about time, it's about consideration.
No, I understand that. And the problem is you cannot tell until the meeting starts how long some of the cases will go on. We have had it works both ways. We once had 20 to deal with, of which we had 8 in the morning and 12 in the afternoon, and we got through the 8 in the morning by 11:30, and therefore there was a wasted 2 hours because we said that the others wouldn't start till 1:30. So the next one we did it the other way round, and we didn't get to some people's cases after they'd been twiddling their thumbs for maybe 6 hours, including paying a surveyor or someone £200 or £300 an hour while they were waiting. It's a very difficult balancing act, we have our next meeting is on the 27th, a fortnight tomorrow, and we will probably have 3 major applications and 7 or 8 other applications, and that is what we're getting as a matter of regular thing in South Norfolk. We are smaller than, for example, North King's Lynn in terms of size and population, but we get quite a large number. As has been already said, we have a very good computer system for interrogating and getting answers out. We hear very good feedback from nearly all of the professionals in the county. They much prefer to come to South Norfolk because the system works properly, whereas in other places it can be a bit hit and miss. I think the lady behind you was indicating, and then I'll take that lady there. Yes, go on, madam.
I just wanted to ask, do you normally do site visits to the site?
We have a situation where, for exceptional applications, we organise a site visit in advance. For example, we had one about 18 months ago involving a wind farm of 2 or was it 3 turbines in Hempnall, and we actually organised a site visit in advance because we knew it was going to be quite difficult, and it is very difficult to envisage how a turbine will sit in the countryside purely by photographs or even by a video simulation. But the last meeting, for example, we had a wind turbine application for 2 wind turbines at Stockton, which the officers recommended that we refused, and we were happy to support their recommendation because it seemed to be exactly correct. And I commented when we were shown a video simulation of the turbines in operation that they seem to be working much faster than I've ever seen them in real life, and in fact they were working at only 1/3 of maximum speed.
Who decides whether it's exceptional then? Say, like, for instance...
Now, well, there's 2 ways. Sorry, the other half is we may have a meeting and we may come to the conclusion that we need a site visit before we can make a decision, and then we will adjourn it to the next meeting and have a site visit in the meantime. That happens about 1 case in 20, and these advanced ones I've just described about the wind turbine one, that is all only once or twice a year, quite exceptional.
I just want to ask, for instance, say if you had strong opposition in the community, would that be considered exceptional?
No, that would in itself not be the reason, because the purpose of the site visit is not to enable people to lobby the members.
Yeah.
The purpose of the site visit is to enable members to see the proposed development in its local context. And if it's an area that's very familiar to members, fine. And indeed, members are encouraged to visit the sites independently.
Yeah.
A site visit is very regulated. Certain people can speak, certain people cannot speak. We had a case recently when we had, in my own ward, we had a site visit because there were 3 applications all very close to each other, and they would all impact on each other, and that was felt to be necessary to have a site visit. But the way in which site visits are handled does depend on the local authority, and I can only tell you how it works in South Norfolk.
Okay, sorry, we are running out of time. I have another question. Can we just take one more question?
Well, that lady was next, actually, and, and this gentleman
and then we'll break the tea, and then
this gentleman can speak
questions.
to me over a cup of tea, perhaps.
Yes.
Oh, yeah, I just wasn't a question, although I do have a question we'll come to later. Point about Heritage England. The situation is that what was English heritage still exists as English heritage, but is there to manage the national collection. It's actually Historic England who now perform the
Thank you for that. I'm a member of English Heritage, but I no longer have to declare that interest because they are no longer the consultee.
It's Historic England.
That's right.
Thank you. So
This
just
lady
to
here,
make-
final question.
Okay, I just wanted to get some clarity really. You gave advice to parish councils to either object or to pass no comment.
Correct.
But would you say advise also that we quote policies as the previous speaker
Very much
mentioned?
so.
Pardon?
Very much so.
Good,
If
okay.
you could quote the policies, that helps. And when it is, as Mr Hook said earlier, the parish council objects because we don't want this man to make money out of selling the properties, or because it will interfere with a view, those are not material considerations. Interfering with a light is a different matter, but a view other than visual impact, and that's not so much a view, but how does it sit in the seat stream? You see, in London, when I was a councillor in London, London Borough of Havering, I was a member there until I moved to Norfolk. A lot of our planning was to do with, did the development intrude beyond the building line in the street? Because you had a built up area with building lines which were very clear, having been built in the 1930s or even earlier. But in most of the villages in South Norfolk, and indeed the whole of Norfolk, you don't have clear building lines that you can apply that rule to. Thank you.
So we should have some reference to policies, even if we don't quote them exactly.
That's correct, but it should be proper policy considerations rather than emotion masquerading as a policy representation.
Sure.
Thank you.
Thank you. I'd like to introduce Christopher Weatherburn from the Prince's Foundation, and he's going to tell us all about BIMBY. And I'll leave that to him.
Perfect. Thank you very much. Yeah, BIMBY, not BIMBO, sometimes to be confused. Sorry to keep you waiting as well. IT issues. When talking about an internet toolkit, it's already good to get one out of the way initially. So who am I and why am I here? Who are the Prince's Foundation, etc. My name is Christopher Weatherburn. I work for the Prince's Foundation as Policy Communications Leader. I'm still trying to unravel what exactly that means, but it's an interesting title nonetheless. The Prince's Foundation, we are a charity set up primarily working in the built environment. We've got 3 different sections. We've got an education team, we've got an enabling team, and then we've got a championing team. The education team, we've got a couple of masters in sustainable urban development, sustainable urban design. We also have young person schemes where they can get various different experience and qualifications in certain things like stonemasonry, ironmongery, thatching, if that's your thing. So we've got kind of a real wide remit in the education department. We've then got an enabling team, which is projects. I don't know if any of you have heard about Poundbury.
Yes.
Feel free to just engage with me. I'm not a very good public speaker if it's just one way, so jump on in. Championing team, the one that I sit in, we're primarily looking at reports, how we can get our basic ethos into the public sphere. So we've got a couple of reports at the moment. We've got estate regeneration, we've got Housing London, where we're talking all about mid-rise housing, and then we've got finally housing communities, what people want, which is where BIMBY came from. We've got about 25 years worth of experience, not me personally, I haven't been there that long, but we've got 25 years worth of experience going into various communities like this and saying, what is it that you want from development in your local area? More often than not, we've found people aren't actually anti-development. They're actually anti the wrong kind of development. So development that doesn't take account of the character, history, uniqueness of a particular place, which is what actually your chairman, Sue Sawyer, said when she came to our event in November last year. So we actively advocate sustainable urban development, sustainable urban urbanism, if you like. There are issues with housing across the country. There isn't enough. I think we all can possibly attest to that at the moment. So how are we going to house these people? Where does it possibly go? We advocate a bottom-up approach, engaging with the communities where development might take place and saying, actually, you are the best people to describe where and what it should look like, where it should go and what it should look like, which is why we kind of came up with BIMBY. It's a way of turning NIMBYs into BIMBYs, people that request beauty in their backyard. We actively think that development can actually improve a place. It can enhance the area in which it is. Obviously, there are issues with that, i.e. where should it go, and what kind of development does it look like? Too often, development is done as a playing by numbers game. You look at a particular area, you think, how many of a certain kind of house can we fit into that particular place? There's no real effort, thought given to placemaking as a type. So what we've said to people is actually engage in the planning process. You now, since 2011, the Localism Act, etc., has come in, you have rights to start neighbourhood planning. Problem is that whilst that's all well and good, giving you the ability to neighbourhood planning, there isn't necessarily the guidance that takes you through it in a way that's understandable, easy, manageable. As people far more intelligent than I have tried to explain, the MPPF isn't a fun document to get into, less so one that's easily readable if you haven't got a planning background. What we've tried to do with BIMBY is take away some of that vernacular that is difficult to get into and say, actually, you are all representing your local areas, you understand what it is that makes this place unique, let's discuss that and then talk about how any development that comes into the area could complement it. So what we did was we created 3 different workshops, of which there's 3 different activities in.
Housing target.
Yeah, and then there should be another one.
Next slide.
Yeah, lovely, thank you. So you've got getting to know your community, identifying sensible areas for new homes, then choosing popular local building types. That's essentially all planning is for me. I mean, there is obviously a lot more to it, but actually it's where should stuff go and what should it look like? And I think everybody in this room could probably engage in a conversation about that. So getting to know your community, there's 3 different exercises that we have. And I have been running it on a kind of 3-hour drop-in session, if you like. The first exercise is getting everybody into a particular room, saying what your particular expertise are in. A lot of people in here will know about the natural environment in your particular area. You could advocate for it, you could speak about it quite eloquently, I imagine, and come a planning appeal, you could talk about that. There are 3 other pillars that we talk about: the social capital in a particular area, the built capital in a particular area, and the financial capital in a particular area. Built is obviously what it looks like architecturally and where it goes. Financial is high street, how's the local economy doing, etc. And then, what was the other one? Social, financial. Social, if you're a teacher, if you understand the social fabric of a particular place. So we get everybody together and we get those people that might be experts in it. In some ways it's setting up a neighbourhood forum. You need 21 people who come from the area with a particular skills and expertise when carrying out neighbourhood planning. This is a way of teasing out those people that you might need to be involved in the process all the way through. We then go on to a nice sticky dots exercise, a map of the local area. You put a green dot on for areas you like, red dot on for areas you dislike, blue dot on for areas you think could be improved. And what that does is, if you get a room full of people like this and more, we've had 400 people odd in Nottingham, where I recently did one, you start to build up a really good idea, a democratic idea of what places people like. If there were to be development in your local area, I would go to an area where there's lots of green dots, and providing it's not a field, because they like it because it's a field, you can have an idea of what it is about the built environment people like there. Also, red dots. If I was a developer that looked at a red dot, I would say that's a good example of something that people around the area don't like. Blue dots, areas that could be improved. You could look at failing community centres particularly, areas of the natural environment where actually there could be more done to look after it. So it's just a nice way of getting everybody involved in a process that actually they should be able to be involved with already. The third element of it is, it's called a community capital matrix, where we say it's rating your area. You've got positives and negatives under those 4 pillars: natural, social, financial, built. And you just say what you like and dislike about that area. What's good about living in the area as is, positive. What's negative about living in that area as is. And all of a sudden you start to shape a really good idea of what it is people in that particular area think is good and bad about living there. And if there was development that's going to take place in future, how that could enhance all of the positives and diminish the negatives. Second section is identifying sensible areas for new homes. I'm sorry, I did have pictures of all of these, but they haven't come out with the conversion from Macs to normal Windows, so bear with me, Imagineer. So what we do is we get a map of the area and we say, you're not local planners. I used to work in a planning authority. It's hard work sometimes, but actually what we advocate is sustainability. Sustainability is a term that can be misused all over the place, but actually when we're talking about it, it's does it last for a long time? Can you walk to the doctors, GPs, etc.? Is it sustainable in terms of creating a community or being part of an existing community rather than creating an in the middle of nowhere housing group? So what we say is, draw concentric circles around various different amenities. Colour in your doctors, colour in bus stops, colour in schools, etc. And then draw circles around them. What you'll see is, where those circles meet in particular areas, that makes sense for development to happen. If you can think about it. We then say shade in all those bits of area on the map where you think makes sense for development to happen. All of a sudden, if you've got a couple of really heavily shaded areas, that would, to me, seem a sustainable place to put new development. And that's you as a community looking at it proactively and saying, this is why we should engage. Again, there are constraints, and I think many people have pointed out before me that actually you really have to engage with your local planning authority. More often than not, community engagement with the local authorities becomes an us versus them. I actually think that's got to turn on its head at some point, otherwise it's just going to continue to be this cycle of everybody getting miserable with each other. If you can proactively work with planning officers, councillors, and say, actually, we might not be planners, but we've got this idea that this place makes sense. You look at it against their constraints map, which you should already have in some ways, then you can actually come to have a discussion, an active discussion about why that place wasn't considered. And you can think, okay, that makes sense to us, why doesn't it? And all of a sudden you're fostering a conversation that might not have had otherwise. Then we go on to the third workshop, and this is probably where the foundation's expertise are, if you like. We were set up by Prince Charles in 1987 with architecture in mind. You can see that from Poundbury if you've seen images. But realistically, the things we're looking for are good design with an idea for it to last a long time. Again, as I said, too often quality goes out of the system, and that's where I really think the teeth for neighbourhood planning exists. You do somewhat make a deal with the devil. You accept that by having these neighbourhood planning rights, there is an acceptance that you will have development in your area. What you do get to say is proactively, this is what it should look like if it comes in this area. My whole message is about proactivity. A lot of the time, people in this room's experience with planning is one of reactivity. It's saying, we were consulted on this, we don't like it. What I'm saying to you is, since the Localism Act and neighbourhood planning laws come into force, you can proactively plan for your areas. You might not like everything that gets decided, but you've never had as much power to engage in a process as you have now. So creating Workshop 3, it's about design. It's about design codes in the old sense of the word, if you like. But you might not have the vernacular of an architect. You might not have the money as a parish council to go and pay somebody to do that. What you can do is you can go into your local area and say, what is it about this particular place that makes it unique? It could be the various different amenities there, and we have a system called 5 essential qualities of place. And what you do is you say, this place represents this particular part of Norwich, for instance, that we're in now. It's close to the water. It's old warehousey district. That's the kind of aesthetic here. There are lots of different elements, if you look at them, that make this place what it is. So come as a group together like this, have that discussion, all of a sudden you'll start to have a really sensible conversation about it. The second one is we say go and take photographs of local houses, local building styles. Again, you might not have the understanding of an architect, but what you do know is what you like and dislike, and you can take a photograph of it. And we say bring all of those photographs to a meeting like this, or get together and decide which ones you like and which ones you think represents the area, then put it into this BIMBY Toolkit, and all of a sudden you'll have a type of building. We then say go and do that with windowsills, chimneys, walls, etc. And then you also have an additional type of construction that will make sense to a developer. And what you do over that period of time is you build up a building house type, you build up an amenities type, and you have you can go to a builder's merchant, or you can go to an architect and say, can you put this into words that are understandable to a local authority? Well, all of a sudden you have a really strong, legally adoptable design code that will be integral to the planning system. The reason you should do a neighbourhood plan in the first place is actually that it is legally adoptable. It's got weight. It's something that you can stick your hat on and say, this is a real piece of legislation that counts. And any decision that's made in the after interim, you will have to go along to the planning meetings as you do now, but you can actually say this legally adopted document has weight. It should be considered, I think about 50% is the rule, as important as the planning regulations that are currently there. It gets adopted into the local plan, it becomes part of the local plan. What it can and can't do, like I said, I mean our background is the built environment. We don't include things like local economy in there, which quite frankly our expertise isn't in. But hopefully this is a quicker way of going through a process that's taken some people 2 or 3 years. When we first started engaging with neighbourhood planning groups, they were concerned that actually it would take a lot of time to get through the process, and some people have. It's taken 2 to 3 years. We suggest that you can go through this process in 2 or 3 workshops, as long as you get the right amount of people there and get the right amount of engagement there. Difficult to do, easy to say, difficult to do, but if you can get it done, you can get something that, again, is legally adoptable into the system in 2 to 3 months, I suggest, is a reasonable way of looking at it. Sorry about whizzing through that there. Is there any questions so far?
Who your clients are?
Who our clients are? Yeah, good question. So a lot of the time I'm now working with neighbourhood forums or parish and town councils who are looking at setting up neighbourhood plans. There are others. So we actually worked in this particular site. I don't know if you know St Mary's Works and the developments going on there. The developer asked us to come along and make sure that the community was properly consulted, and what we did was we held a workshop in this very room with lots of people that live around the area, also local business owners, etc. And we said exactly that. So if this place is going to be developed, which it was, how should it look? How should it represent the area? What do you think would benefit the area? At the moment, it's not a particularly well-used site. So in future, if there is going to be housing here, solving the housing crisis, what should it look like and how can the local community benefit from it?
How do you deal with, give you an instance, in Dis, we only seem to ever get one developer, and it seems as though it's been carved up. Persimmon have got, they're the only company that build in Dis, and also when it comes to affordable housing, when they do a plan, they stick a whole terrace up in one corner, backing onto people's bungalows that are already there, and anyway, the application there was thrown out, but it will come back again. But it's getting architectural design, you know, from a major builder, and you can't offset it by bringing in other builders because they just don't apply. You know?
Sure. I mean, the foundation has done work in other areas where we've actually worked alongside people like Persimmon, Taylor Wimpey's, etc. The difficulty is in any conversation is the land value. How do you get the amount of money out of the land so that all of a sudden they can take the hit, if you like, and pay more for quality in the built environment? We'd suggest having the community on side. If you create a neighbourhood plan, if you get something into the planning system which is, again, legally adopted, all of a sudden the developer knows if he plays by those rules that you've set out for him. If you've said, if you build here with this type of vernacular architecture, this type of windowsill, etc., you will have a lot easier ride with the local community, with the council, etc. Then I would consider that a win-win if I were a developer. Again, like I said, that triangle of developers, local authorities, and communities. It is a fractious one. It's one that's built up on mistrust, planning by appeal, that kind of problem. If you can have a proactive discussion at the very outset, whatever's gone on before, if you're planning for the next 10, 20 years now, I would want to have that discussion with them proactively, and say, actually, can we build a place? Can we build something that's there, a somewhere place rather than an anywhere place, if you like, as a line for you.
Just a quick point on your, right at the beginning, your assumption was that there is a shortage of housing in this country.
Yeah.
I would contest that's not the case, or I would say there's an absolute shortage of housing that people can afford to live in.
Yeah.
It's not that there isn't housing stock available, and it isn't that there isn't brownfield sites with industrial units on that can be redeveloped. That doesn't make money.
I would agree with you. I think we always advocate brownfield land. If you look at the amount of permissions that are currently existing, I saw CPRE tweeted something that there's actually already enough permissions out there at the moment to solve the crisis, and I think that's probably true.
Absolutely, it's there. It's solvable. Absolutely solvable.
But,
and I've just come back from Lewisham, where I was looking at this community project in Grove Park, where there is land of old garages. The proposal is to put up 20 accommodation units to feed a local community centre to accommodate nurses, teachers and other key workers in that area. The developers have literally just jammed through an application to put up 7 luxury homes on that same piece of land.
Yeah. London is its own beast. It's bonkers, and actually you have an issue with mayoral powers that nullify certain things. What I would say is that we always advocate brownfield. We have CPRE as a partner for that very reason. But you can't stop the fact that actually those houses aren't being built at the rate they are, that has been suggested. That's part of the problem with the 5-year land supply.
And land bank. And people hang on to it until everybody needs to make, maximise their profit.
Absolutely, to a certain extent, I think that's part of the problem. More and more, I'm speaking to people that actually understand there is a need for housing. They want the 30-year-old son to move out of home so that they can enjoy themselves. But how do we do that, and where do they go? I think if you, as a local person, know of a brownfield site that's not being built on at the rate it should be, or hasn't been considered previously, you're well within your rights to go through this process and say, actually, this is what I'd suggest. Again, it's not going to answer all of the problems, but it's a start. And I think that's the start of a conversation that's hopefully, again, the start of a movement which will lead to...
I'm more involved with actually adaptive reuse of listed buildings.
Yeah.
I'm a historic building conservative, so I'm
Yeah.
looking at using historic buildings, listed buildings, as focus for community. Not the housing, but actually the infrastructure for the community. And then there's industrial land available to then put affordable housing on. But what is affordable housing?
That's the question. It's
Affordable to a developer is not affordable to
by the government's own definition, it's £250,000 or £450,000 in London.
Yeah.
As a young person that's living in London, I can tell you it's not affordable, but that's just... Sorry.
Do the same principles apply for commercial development?
We don't use this in commercial development. This is strictly for neighbourhood groups to start planning proactively in the process, getting involved in the process, so that it doesn't become you appealing a decision that's already made. It's you proactively saying, let's get involved in the process.
Because our parish, it's commercial development that's affecting our parish, so could we not put together kind of like something similar in the neighbourhood plan?
I mean, I hope that what we've tried to do with BIMBY is just set out a very simple, this is what you need to do, these are the people you need to have there, these are the kind of materials you need, things that groups of people don't necessarily think about, i.e. signage, i.e. pens and papers, compasses. If you follow the formula of getting the people together, then absolutely. But again, we strictly stick with residential and built environment in that sense.
I just have one more question, but I think the gentleman...
Yeah, no, I just
first.
found your comment about sustainability interesting and quite funny, really. If it's not in the middle of nowhere, then it can be deemed sustainable. Could you go into a little bit more detail of your interpretation of sustainability, please?
Sure. I mean, I caveated by saying it's a word that can be used and be misused. In our terms, so a sustainable building, for instance, is one that's built to last for 1,000 years rather than built for 50. There is a study that I was listening to earlier on that said if currently we all need to live in houses that last 1,000 years, otherwise the rate that we build out won't actually mean anything because the houses are going to be knocked down and rebuilt, etc. Having buildings that
that's one indicator.
That's one indicator.
A house that will last 1,000 years.
Well, no, don't.
Serious?
I wouldn't say 1,000 years, but the aim to exist for a long time rather than just knocked up.
Yeah.
The other side of it is that it can be reused as different types of building, like somebody suggested there. That it's not always just going to be a residential home. It could be an office block. It could be something, but the building itself doesn't change or doesn't move. Sustainability in terms of not needing cars. Sustainability in walkable catchment areas. I think there's been lots of studies that have gone into health and well-being and communities. But if you can walk to your local doctors, if you can walk to your schools, etc., that's much better for you. It's much better for the environment. If you have windows that are big, that let lots of natural sunlight in, it's far better for mental well-being, etc. So there's lots of different things that I think sustainability does.
They're the ones I've heard previously.
Mm-hmm.
We don't have a right to life.
You don't. Well,
enshrined in legislation.
Well, I mean,
it's not. It's everybody would like it, but there's no legal.
What we've built into this is so the BIMBY Toolkit. You enter in all these various different things. You go through these hoops that I suggested you go through, and then what it spits out at the end of it is a housing manual, something that you can give to your local authority and say, this is our neighbourhood plan, if you like. This is what we suggest is adoptable for our particular area. And in that, we've included lots of different things like windows with door frames, etc., chimneys, all of this different stuff that you can put in, but also we've provided for you how far it should be set back from the street, and that's things that we've learned from Poundbury, Sherford, where we've been working, Cornwall, just all across the country, that we know can be adoptable.
Do you have a sort of a subsection of how you evaluate how people might use public transport, for example? Because the developers are putting forward the idea that people will use public transport in the development they want to create near me. I'd like some analysis on that because a lot of the local people don't use it. You see the bus travelling around and they're empty. So,
Again, I mean, what we suggest is that you use bus stops, etc., as an example of somewhere that's connected, if you
oh,
like.
there's one nearby.
Yeah.
Not not disagreeing with that.
Sure.
But most
It's
people
available,
don't
but people
have to
just
use a car
tend
because
not
it
to
doesn't
use
fit
it.
in the bus route.
I think development takes place, and I know we're under time pressure, but
Yeah.
development usually takes place along transport links. That's how it's always been done. It's because you build around existing transport. That's why people do it around TfL sites. If you go up and down the train lines, development has traditionally moved out and out and out alongside those various different...
But in your toolkit, is there any system which enables me to evaluate if public transport will actually be used?
We don't go into that, no. We're talking about proactively saying, if something comes here, this is what we'd like to see. This is why we think something should go here, rather than, again, kind of coming from a slightly negative standpoint of saying, actually, it's not well connected.
No, I was looking negative.
No, I know you're not. We're
I
always...
use
No.
I evaluate.
Yeah, absolutely, and we always just suggest go from a position of proactivity, positivity, because that's the better way of engaging.
Okay, thank you for the question. And one last.
Thank you. Planning application, 200 houses in our village on a green agricultural field. It's been rejected by the North District Council. It's outside the planning framework, it's outside the core strategy. Why should we want a neighbourhood plan?
Absolutely fair question. I would suggest that you want a neighbourhood plan to get involved in the process and to say, actually, things might not always be rejected. You don't know how long things will last for. It might be that somebody comes back and puts in a 50 home suggestion application, thank you for the word, and all of a sudden that might be accepted. What I'd say is, if you write a neighbourhood plan, you have a proactive way of getting involved into it. You can actually have something that you get adopted as part of the local plan that says, we'd be okay with 30 homes.
But it's
they
the
have to
5-year
look
land
like
supply
this.
that really is critical, yeah?
Yeah, at a county level, at the district level, sorry, absolutely, it is. But if you have lots of people like yourself who are interested in not just saying, no, we don't want anything, but are interested in saying something would be acceptable as long as it looks alongside this kind of design, all of a sudden, if everybody does that, and you have all the various different parishes doing that in a particular district, all of a sudden their 5-year land supply gets built up, and you have a certain protection against it. The problem is as a local authority worker once was, you get lots of people saying, we don't want it here, we don't want it here, we don't want it here, and you're constantly fighting a least resistance cause.
Okay. Thank you.
No,
Thank you,
no.
Christopher.
Cheers.
We've got 2 more things to do. One is Helen's just been talk for 5 minutes.
5 minutes.
About
Max. Bits and bobs.
the CPRE Norfolk planning framework, and then I'll ask the 3 speakers to come to the end, and we'll take the last half an hour just to deal with all the other questions. Your question first.
Okay, so again, thank you all for coming today, and I think it's been a very interesting afternoon. Just want to explain a bit of the background for the impetus for today, which grew out of a Volunteers' Day that we had back in January. And really what we're hoping to achieve is a sort of CPRE planning network, if you like. We already have volunteers, wardens who look at footpaths, look at litter, and I'd like to establish sort of planning wardens, if you like, CPRE planning wardens. And in your pack that you will have had one at this form here about joining up the network. So if you would like to, and you haven't already filled that in, I would encourage you, please, to fill that in. And the idea that I hope we get behind it is that you will sort of work with each other. So instead of this group here and that group there and that group there, all sort of reinventing the wheel from scratch, you can all talk to each other, learn from each other's experiences and expertise and so on. And I think, there's a real sort of strength in numbers. And the other thing is that, of course, it doesn't then all have to just rely on me, who is no planning expert by any stretch of the imagination, and 1 or 2 of our trustees. We will still be there to help and advise, and we'll still have our sort of standard, publications and letters and advice that we will give you, and that will never disappear. But what I want you to feel is that you can cooperate and work alongside each other as well. So please do fill in that. And also one of the questions on there is if you might be willing to be a regional organiser of the network. So, and I also want to say, as well as the sort of local support from us, there is masses and masses of support from head office. And if you haven't already looked at the CPRE national website, please do so. I've got the site up here, so you just go CPRE, and this is the main website. And if you click on resources up here, and then down the left-hand side here, you'll see all the various sort of campaign subjects. And if you click on housing and planning there, you will see that there are loads and loads and loads of different reports, briefing documents, all sorts of things on all kinds of subjects that are there for you to read, to download, to do whatever you like. We have a fantastic team of very knowledgeable experts who work at head office, who work incredibly hard to research and put together reports, and it's all there for you to use. So please, please, please do use this as a resource, because there's some very powerful and useful stuff on there on all sorts of subjects. So that's pretty much all I've got to say really, except for the last point, which is that we do have a planning hotline to the head office as well. It's currently a little bit in limbo because we're just recruiting our new senior planning policy officer, who hasn't quite been appointed yet, but under normal circumstances, if it's those little cards that are on the table over there, those little brown cards, and it's planninghelp.cpre.org.uk, and they are there to help you. That's what they're there for, so please do use them. And also there's not many publications left, but please do clear the table of whatever is left there for you. So that's it. So, you know, we're here to help you as well, as much as we can. We can't get involved in tiny little things, as David said before, but that's really the impetus behind today. I'm so pleased to see so many of you here today as well, so thank you very much for that.
Thank you, Helen. So if I could ask our speakers to please join us.
Yes, I don't really want to just fill in all the details if they want to. Just pass it around. Yes, yes. If you have, I think Ken's already filled that one in. Yes, please do. Thank you. Yes, that's brilliant, Christopher. Thank you.
Now we're going to come right
You're going to come. You're going to come.
Okay, for our last session, any other questions that I will try to direct to the right person, but you may want to direct to myself. The very first question is from the lady.
Well, I was going to ask a question about, you mentioned triple SIs, but we've got 5 county wildlife sites within the village, and we're right next to a triple SI, it's across the other side of the road, which is obviously a European protected site as well. How much impetus, how much importance does the planning committee take to that sort of thing? And it's a completely untouched pingus and meres and things like that, with lots of protected species in there, but that's one of the problems that we have. The Norfolk Biodiversity Service database, most of the information of the surveys that have been done in these county wildlife sites is at least 20 years out of date, and we're running against time to try and get. We can't prove what's in there apart from what we know is there, but we haven't got expert proof of what's in these county wildlife sites to go to we know it's there, but we can't prove it's there because we haven't got experts in to see it, and we haven't got time to get experts in to see it.
Okay, so your question is, you've got protected sites in the village,
yep,
and you want to know how the council goes about looking at those sites and dealing with that protection.
Because this is the planning for a development. We're a hamlet with no main drains or any facilities or sustainable things. We've got no public transport or anything, and they want to put 8 massive houses in an estate and dig up pingus and turn them into water features and things. So we kind of obviously don't particularly want that, clearly. But how would it be viewed from a planning committee point of view?
Councillor Kemp, can you?
The committee has to give a lot of weight to the status of an SSSI. A county wildlife site also. Such an application, I can't say how it will be dealt with in other areas, but in South Norfolk, such an application you would require a pre-application ecological survey which the developer has to produce.
Well, they have done that, but they've just done a tabletop survey
Well,
using
you
the
see,
biodiversity database.
can be one of the problems, that you just get a tabletop exercise, and if members are not satisfied with that, we then have to ask for further work to be done, and we have to identify what the further work is, and that is where we need informed contributions to the process, directing our attention to particular areas where further work may well be appropriate. And you've got to bear in mind that certain species are desirable, but certain species are protected, and issues of that nature. One of the biggest mistakes that can be made when you are not happy with an exercise that's been carried out by an expert is to suggest that the expert is biased because he's paid by the developer. That is that doesn't necessarily follow, because if the expert is a true professional, it shouldn't matter who is paying them, because their duty is higher than to the person who's actually paying their fee. But not everybody is as meticulous as some of us about those sorts of standards. But it's never good to make that your sole objection, or even your principal objection, to the developer's survey, that the developer has paid for it. Because the developer is paying for it not to benefit himself, but to assist the committee in reaching an appropriate decision. Beyond that, those sort of general points, you've really got to lay the groundwork so that members can say this is not adequate for the following reasons. Just a sort of vague unease will not suffice.
Right, but the problem is if the data is all at least 20 years out of date, we're not suggesting that the survey is wrong, but it's just extremely out of date.
Can I? David?
Well, that's a valid point as well.
Yes, David, can you?
Yeah, I mean, this very issue came up with the wind turbine application that Christopher was referred to in Hemphill recently, where the action group objected to the quality of the surveys carried out on bats. So Christopher's quite right. A professional, whoever should apply professional standards, whoever's paying them. You could also look at it from another point of view, that there are very few professionals employed by developers who do not. There are very few that contradict what the developer wants to hear. So what that means, I would like, and this isn't the CPRE policy, I think that independent experts should be employed, paid for by the developer. I think that would be a fairer kind of situation in all these ones. But I would advise you to get together with other people who are concerned and pay your own expert to produce a professional assessment of the sites and their importance and how the development will contradict with them, and then supply that to your LPA. It will cost money, because an expert, unless you find one locally who's as concerned as you, who'll do it pro bono, experts cost quite a lot.
What they do in the courts now, because I used to do litigation work, civil injury litigation work, and I have in the past had medical experts say to me, what do you want me to report? And I told them, I'm not going to use you because you're going to be influenced by what I want. I only want the truth. But then not everybody applies the same standards, and those of us who are fairly old school perhaps have a different approach to some others. But because there was an issue with that, and because judges were getting fed up with having to decide which medical expert was correct when they didn't necessarily have the right skills. There is now in personal injury claims, for example, a requirement that an expert is appointed by the court, which means by agreement between the parties, but at the cost of the parties. So initially, the parties will pay, and then whoever loses the case will reimburse the winner for their half of the fees. Now, unfortunately, planning doesn't work like that, but that is a sort of parallel that may have to be developed, perhaps. But the difficulty is, in many of these areas, it is finding someone who actually has the requisite expertise, because some of this expertise is very sub-specialist. And you can get people, you can get an expert who will, this is the best analogy, example I can come up with, but I spent part of my career professional career working for the British Railways Board, and we had a case where the expert against us was an expert in steam engineering, and we actually needed an expert in diesel engineering, and there's a complete difference to the way in which gearing works in a steam engine and a diesel engine, and as a consequence we had completely the wrong expert, and we had to start all over again. And you get those sorts of issues that you need to address very carefully, but very often I find that a local person who has got not necessarily the expertise but a good grasp of the issues can put forward something that will pass muster as an answer, or will pass muster as a sufficient answer for members to say, go away developer, we want someone who has actually visited the site. I can remember at least 3 or 4 applications in the last year when the expert has been there. We have a lot of problems in South Norfolk with drainage, and you get people coming up with suds and infiltration systems and all these different things, for some of which, you know, I'm not a hydraulic engineer, I only have a vague idea. All I know is that water doesn't run uphill, but some of them don't seem to understand that when you look into it. And the men who drained the fens didn't realise that until halfway through the work, but that's a historical point. But the point I'm making is, very often a local person can produce enough information to give you the lead that you need. I have asked experts in the past, your report is very interesting. How many times did you visit the site? None. You know, members need to be prompted to ask that question, not by you saying, will you ask him how many times he visited the site, but because one of your local people, who may be a retired engineer in a parallel field, can come up with enough of a case to show that there needs to be more work there. Okay. You have resources in your villages and in the areas where you live. You need to mobilise them rather than struggle on with inadequate resources.
Okay, thank you.
The lady is
No, I was just going to say that
excited.
it's interesting what you say, that because in our area, quite local to where I happen to live, middle of absolutely nowhere, a planning application was put in for a pig fattening unit, and everybody thought that it was in somebody else's territory, you know, because it turned out that it was right in the middle of a conjunction of 3 different parish councils. It got very confused as to who knew what. But the person that put in the application had got a professional company to put in all the good reasons why it must happen. And one of the things they said was that there was a mature hedgerow that went around acres of this field so that it would protect the general public from the view. It's on the Tass Valley Way and everything, so it was significant. And in fact, there was no hedgerow there at all. There was nothing. Absolutely nothing. So it was quite clear that not only had the parish council who passed it been to visit this place, but that the person that was the agent who was putting forward this apparently very professional document, they hadn't looked at it either. If they had, they just chose to lie about it. It was bizarre.
one of the big problems is people who actually only look at things on desktops, on Google Maps, without going and actually looking at the site. And that's where it's important what you do locally, because you know the site, and you need to make sure your local councillor, if you're using your local councillor for this purpose, either comes and looks around it with you or professes to know it well enough from you having spoken to them.
Okay, I'll move on from there. I saw the lady.
Yeah, it's okay.
Okay, fine. Jump
Just
on.
a comment on ecological surveys. It's my understanding that you have to take into account a 2 kilometre radius of the site, and it's quite evident in lots of situations that it's been a tabletop exercise, because some of the things which are obvious to, as you say, local people, local knowledge, have not been picked up at all, linked to the actual situation where the surveyor had only been on site for about half an hour, and there's no way you can cover all the eventualities for an ecological survey in a half an hour site visit, because it doesn't take all the climatic changes throughout the year, etc.
Well, that's another factor as well, if I may say so, because the outcome of an ecological survey can depend upon the time of year, and indeed on the recent weather in the 2 or 3 days beforehand, and that needs to be clear in the survey itself. I mean, it's not always made very clear, and what you've just said, sir, is relates back to an earlier question we had about site visits, because very often an incidental advantage of persuading the members that they should have a site visit is that will very often lead to the developer actually having his expert on site at the time of the site visit. And I have certainly been on 3 or 4 site visits where problems were resolved as a result of people getting together, as it were, not during the site visit but after the site visit, because they saw the way the wind was blowing, to come up with solutions to problems that perhaps they wouldn't have come up with unless the site visit had provided the prompt or framework for that to happen. But that doesn't mean to say you call a site visit hoping to do that. You've got to have planning grounds to call for a site visit. You've got to say that there's a material consideration that needs to be, the word might be better elucidated, the phrase might be better elucidated, clearer from actually seeing it rather in 3D rather than in 2D.
Thank you. I've got 2, so I'll take one first.
I appreciate the legal nicety that the law weighs the evidence, not counts it. But the implication of that is one perfectly judged letter is enough to oppose a planning application. In the real world, 80% correct letters, I suspect, will weigh more heavily on the elected members.
David, do you want to?
Yeah, because I listened very intently to Chris on this one. He's technically absolutely correct.
In the real world.
If a point is well made in one letter, it's on the agenda and needs to be a material consideration. But I concur with you completely that I'm sure that if 1,000 letters of objection are received in a democratic, where people depend on votes, and Chris, wonderful defence of our parliamentary democratic system and our local system, I'm sure that does weigh on people's minds, even though it's not in theory supposed to increase the chances of the objection succeeding. And I will give you an example again relating to the same application, the wind turbine application for Kemp for 2 turbines, where the Secretary of State, when he called it in for his decision, and not allowing so that the planning inspector only made a recommendation. He said that the strength of local opposition, 1,300 letters of objection and members of an opposition group, is one of the reasons why he called the application in for his decision. So quantity, even though in theory it doesn't count, quantity makes a huge difference.
The Secretary of State is allowed to do that.
Yeah.
But be very careful if you're going to go down that road, because I once, this was when I was London Borough of Haven. I was the chairman of the Education Committee, and I had to deal with issues about school closures and things of that sort. That's when education was totally under local authorities, not half and half, and gradually fading away as it is at the moment. And we once had a petition and I was asked how would we deal with this petition, and I said, can I have a look at it? And I looked at the first page of it, and it had the signature on the third from bottom, Mickey Mouse, Florida. So I said, completely disregard it. It's got a false signature in it. You can't put any reliance on it. So do be very careful that you only have genuine signatures if you're going to do a petition. The most famous example of that in history is the Chartist petition that was presented in 1848, contained the signature of Victoria Rex.
No, Chris was quite right, and I would advise letters of objection rather than petitions. And one further point on that, if one person says the visual impact is unacceptable, that could be their prejudice. If 300 people write, even if that's making the same point and making the same policy reference to it, that the visual impact is unacceptable, then surely that says something about the visual impact, more than one person saying it. And although it shouldn't make a difference, I suspect that, I don't know, if I was a democratically elected councillor and I saw 1,300, I know I sit in the parish council, we can only object or make no comment, but I know if 50 people turn up at a meeting and start looking at us, it's very unusual for the councillors to ever contradict the 50 people in the room.
There is a tactical point, if I can make this for you. If you are able to organise the people who write the letters, it's what's called elegant variation. Try and make each one slightly different, but also think in terms of a map of the area. And certainly at South Norfolk, we have a map shown on the screen with all the addresses from which letters have been received marked. And it is helpful to know if they are all round the site or if they are just found part of the site. And certainly when we have a case where there's 7 objections and 5 of them are 2 miles away, we don't give very much account of those who are a long distance away. You give more account to those that are closer. So I think that is a tactical tip. I'm not saying whether this is the correct process, but if you're going to go down this road, be effective about it.
Okay, so it's quantity, quality and relevance.
And location.
3 words. And location. Now I had it's on the back here, isn't it?
You've now moved on to another topic, so it seems a bit
Okay,
pointless.
fine. Lady.
I've got a question for Councillor Kemp about lobbying the planning committee. We have an application in our parish where we actually wrote to every member of the planning committee, and not one member declared it at the committee meeting. That they've been
I hope that wasn't in South Norfolk.
No, it wasn't.
Because we are very meticulous about that, and we have a person called the monitoring officer who supervises that we're complying with the rules. And we have a pre-meeting, we start at 10 o'clock, but at 9 o'clock we have a meeting with the planning officers and the monitoring officer, and we say to the planning officer, we're going to ask these questions, can you make sure you've got the right file with you in the building, or in the room, they're all in the one building, so we don't have to adjourn while you go and find the papers. And we also say to the monitoring officer, this is what's been happening, how do we declare this so we comply with the rules? Whether everybody else is as meticulous as we are about this, I do not know, but I am, as a solicitor, I was imbued with the need for meticulous professional standards, and I expect the same rules to apply in local government, and they do by and large, we are very careful about this. Some local authorities, there have been really major mistakes made in this regard, and sometimes they haven't simply been mistakes, they have been fraudulent. And the leader of a council in Lincolnshire about 6 years ago was unseated and went to prison because he sat on a planning committee that was making a decision about a road widening which involved compulsory purchase of some land from him. Those sorts of issues, some people just ignore the rules, but the rules are there and they must be followed.
So would that be worth
And I actually give lectures to people about these rules, and some of the examples that I can quote if I have to go back 200 or 300 years, and they're quite amusing in themselves.
So So would it be worth me placing a formal complaint to the council?
How long ago did this happen?
Gosh, about 2 months ago.
3 months?
About 2 months.
Yes. What you have to do is you either have to, and no member declared that they've been lobbied by the parish council. No. So you've got 2 ways of dealing with that. One is that you write to the monitoring officer of your local authority and say, this is the situation. But you'd realise you're making a complaint against each individual member. Or the other way that you can deal with it is write to the chief executive and say, this is a matter which you think should go to the local government ombudsman as an example of maladministration. Now, normally, if it goes to the chief executive and there's talk of referring it to the ombudsman, who for our area is based in Coventry, the chief executive gets into a panic and sorts it out as quickly as possible. So that may well, but certainly that's what happens in our area, in our district, and it only ever happens about once every 3 years because we're fairly meticulous about these things. But some people, I regret to say, are a little bit sloppy, and it's the sloppy ones that give us the rules that we all have to follow.
Okay, thank you.
A couple of questions on neighbourhood plans and their status. It was mentioned earlier that the neighbourhood plan doesn't count for very much if you don't meet the criteria for the 5-year housing
Correct.
supply. Does that mean that it doesn't count for anything at all? And then the second question is a similar nature. If an area is working on a neighbourhood plan but it's not yet completed, I've been told on one occasion that it could still be considered and have some impact. Does it have any impact at all until such time as it's gone right the way through all the processes and there it is, it's been signed, sealed and delivered?
When it's adopted and the plan is actually made by the local authority, it's passed by a resolution, it's passed by a referendum of the neighbourhood. We've had 2 in South Norfolk. Both of them were passed with more than 90% support. We've had the Crinkleford one, which was 2 years ago, maybe 3 years ago now. And there's just been one adopted in Mulbarton. But I said to my colleague in the council chamber, while we were voting on the Mulbarton one, I said, this is actually going to cause more problems than it's worth, because it is so vaguely worded that it can be interpreted almost any way you like on all of the issues. And that's one of the problems, to get it past the the examiner. It's the same sort of person, but here they're called an examiner. You have to hedge it. In Cringleford, for example, there is an area of land allocated for new housing, approximately 1,200 houses. The neighbourhood, the parish council wanted it to say not more than 1,200 houses. The inspector said, the examiner said, no, it must be approximately 1,200. For the past 2 years, I've been arguing with the officers what approximately means. And of course, approximately comes from a Latin phrase which means approaching. So there's even an argument that says it mustn't be more than 1,200, and how close could it be below? But anyway, the situation is an inspector on appeal has allowed a second application on part of this land where they've already got permission for 800, for another 650, and there is still land left in the allocated area, and they could end up with over 2,000 houses. And I can't see how you can call that approximately 1,200, but it is overridden because of the 5-year land supply. And the 5-year land supply, as somebody else said, varies almost daily because it can be manipulated by the way that developers proceed. Point number one. Point number two, it does apply in other respects. For example, and I am not expressing a view as to whether or not this application should be supported, but there is an application being made by the UEA to develop a large playing field area which includes part of Cringleford, and the proposal is inconsistent with the Cringleford Neighbourhood Development Plan. And one of the issues that the committee upon which I sit, which is why I'm being guarded in what I say, will have to determine is what weight does it give to the land allocation in the plan in relation to that application, because that part of the plan is not overridden by the lack of the 5-year land supply. The lack of 5-year land supply only means that the plan is out of date as regards housing, not as regards business development, open space or other issues covered by the planning application.
And does it carry any weight prior to its being adopted?
It carries some weight when it's 2/3 of the way through the process, and a little more weight when it's 3/4 of the way, and gradually, but it doesn't, it's not really that decisive until it's actually been made. And in theory, the council can refuse to make it even if it's passed the referendum, but you could only do so if you effectively said this is unlawful and it can't be passed by the examiner, because the examiner has to give a certificate that it's lawful before it even goes to referendum.
One big, huge health warning with neighbourhood plans, they have to dovetail with higher level plans.
Absolutely.
You cannot, in your parish, say we don't want any houses here. We'll have a neighbourhood plan that will give us protection against those things. It has to fit in with the housing targets in the core strategy, the strategic plan, or joint core strategy in the case of South Norfolk and Broadland, and also with the NPPF. So until it's declared, and it won't be declared lawful unless it does. So it is not true localism. It is not a chance for people who live there to determine what they want in their place.
It's localism within a national framework. International framework in some ways. But the other point to remember about it as well is you do need the first batch, which included Pringleford, they had a small government grant towards the cost. But if you now have a neighbourhood plan, your parish has to pay for the referendum, and that costs about £12,000 because they have to hire the room and the clerks, the print ballot papers and all that sort of stuff. And if you haven't got a planner as a member of your parish council, you've got a problem. But or what's it called now? It used to be called the Norwich Rural Community Council, but it's changed its name now. It's called CAN now, I think, Community Association of Norfolk or something like that. They have, and one of our councillors actually is their enabling officer, and you can get a grant that he will give, for him to give you 3 days of his time to point you in the right direction to get that sort of expertise anywhere in Norfolk to put forward a neighbourhood plan. Now that doesn't mean that they do it for you, but what that means is they identify someone who will do it for you at a price that perhaps it's worth your while affording.
Okay, thank you.
Have you got any?
I mean, there is an organisation called Locality which provide the funding for it. It's about £8,000, up to £8,000 over a period of time, and then further for particular problems. The validity of a neighbourhood plan is there. It's a material consideration for any planning application. It relies on constant engagement, but actually the whole process of you going through it means that there is an old adage that the best form of defence is attack. That's exactly what this is. You're creating something alongside the planning authority that has weight, that has to be considered, and so every time a planning application comes through, you can point to it and say, look, this has been legally adopted as exactly the same weight as the local plan, which it becomes part of. If you read the local plan experts group plans for what's going to happen in the planning world, number one, it's particularly dull, but number two, there is an increasing amount of weight going towards neighbourhood planning. It's philosophical, it's based on the idea that actually localism is important to the government. I understand the idea that government gives with one hand and takes away with the other. But actually, increasingly neighbourhood plans are being given more and more significance. How that will pay out, I don't know. All I would suggest is the groups that I've got involved with so far, a couple of them have been council-led. Most of them have officer time. There is a duty to support from council officers in the same way that there is a duty to cooperate. Help is out there from people like ourselves, RTPI, all over the place. There is nothing to stop you getting involved in the process, and actually going through the process you'll start to understand things far better So rather than just constantly wanting to object to things, actually you'll have a fuller idea of why some things make sense more than others.
I recommend the RTPI, Royal Town Planning Institution website, because it's got a lot of very helpful material on it. And you're quite right. We have a monitoring service that we subscribe to, whereby you look at the planning decisions being made by the inspectors and the judicial review decisions. And it's quite right, there is greater weight being given to neighbourhood plans, but that doesn't get round the 5-year land supply, but it does mean that in other areas they are being given greater weight. And you do get this, it's a sort of trend in judicial decisions. I used to do a lot of employment law work, and you get trends in how employment law issues about reasonable conduct and things of that sort are interpreted, and they move in certain directions at different times.
I would just say we don't advocate suggesting a certain amount of housing. It's out of your remit, you don't have the power. Constantly I find my time with people expectation managing. They think that neighbourhood planning will all of a sudden answer a lot of problems, and it doesn't. What it does do is it gives you a voice in a meaningful way. You can engage with the local planning authority properly, if you like, and you don't have the right to say how many houses on a certain site. You do have the opportunity to say some sites make more sense than others. And in turn, you also have, that's what I said during my garbled speech, that actually I think the real teeth currently of neighbourhood planning is over design. It's come with the presumption that actually design has really gone out of the whole conversation about planning. It's really gone down in importance as numbers importance has gone up. So getting involved in the design aspect of things. If you suggest that a particular area is represented by terraced housing because that's what's currently there, all of a sudden you start to have a conversation over the amount of houses that could be on that site. But again, it's about proactivity, engaging with the process rather than sitting back and being upset with the decision.
We have, for example, in the one that we just looked at Melbarton, it has reflected on the council's policy in our development management policies of looking for more single-storey dwellings. Now, we can't call them bungalows for some reason, but if you call them single-storey dwellings, and we had to show there was a demographic case for that, and there is, because of the increase in ageing population, more people needing houses without stairs. And we were able to persuade whoever we needed to persuade that we could look in certain sites for as many as 1 in 4 single-storey dwellings. And that's the sort of thing that you could quite legitimately include in the neighbourhood plan.
From just one point, there is a distinction in the Joint Core Strategy area between the rural policy, the Norwich policy area, where there is a deficiency in 5-year land supply, and the rural areas where there's not. Now, the housing targets by and large in the rural areas are much lower.
Yes.
So parishes in rural areas, small parishes who are happy with their place in the settlement hierarchy, maybe have got a site-specific allocation of 20 houses, a neighbourhood plan there can actually be in line with what people want. And I see a lot of validity for those places taking part in the process. But Christopher's been through it in Cringleford. I suspect Melbarton will have the same, where they're in the Norwich policy area, where they can be trumped at every possible point to have more and more houses. And you've got to remember, these housing targets are minimum, I think the wording we looked in the Joint Core Strategy is minimum allocations. And when we showed and demonstrated to the inspector that there was an 11,000 oversupply of housing in the Joint Core Strategy area relative to ONS household projection figures, and the maths was accepted, it was trumped by the fact that this government encourages an oversupply. And so even when we won, we lost. So I do agree, and I think CPRE is on this, that the housing targets, and I know it's out of Christopher's control and it's out of everybody's control, the big threat to Norfolk now is excessive housing targets. And the gentleman made the point, they're not related, and CPRE research nationally showed they're 20 to 30% higher than ONS trends of household creation. And unless we collectively can get those housing targets down, what we love is gone. And I'm sorry, I've gone off the point there, but I wanted to make that point.
It's not just Norfolk either.
It's not just
Okay,
Norfolk.
I've got 4 hands showing. 1, 2, 3, 4. So.
Thank you. I've been trying to understand the National Policy Planning Framework document. The key point, as I understand it, is paragraph 13 or 17. It says if a local planning authority doesn't have this 5-year housing land supply, then a proposal will have the presumption of being sustainable and the presumption of a green light, unless you can show that it's not sustainable.
Yes.
So as you said in your talk, I don't know exactly what sustainable means, can mean many different things. And also it's a matter of not black and white, but for example the sewerage, does that take 5 years to be put in place or 1 year, and so on, and traffic impacts, that's a very variable thing. So I don't know if you have any tips on that, finding objections. I guess they're the same thing as material considerations. And then the second thing, I read a bit further, and it went into an annex, I think, about the Liverpool method for the 5-year housing supply, something else.
And the
one of you said it can be manipulated. Is there any area there that can be challenged? And there have been court cases on this. And then lastly, shouldn't this be taken up at a national level? In fact, someone hinted that the government is looking at this because it's such a blunt instrument. But it leads to such sort of arbitrary proposals and puts aside the whole of the planning process.
The problem with this, the MPPF, is it starts off by saying what sustainability is, and then in the last paragraph it says anything that complies with this policy is sustainable. So it's a circular definition without any real meaning, and that's why, as I was saying to somebody in the tea break, planning law is 2,000 pages times 6 volumes of a loose leaf encyclopedia, which is updated on a weekly basis with a great thick wodge of new pages every week. And most local authorities that have planning lawyers, they mostly shared through the MP law, which is based in County Hall, will have a fairly senior clerk whose sole job is updating the book to make sure that members are given advice based on the current law. That is one of the basic issues. There are so many planning inspectors, and they're all based in Bristol. In fact, we had a case in South Norfolk when a planning inspector was one of the key objectors to a particular application, and it was quite interesting to. We had an interesting conversation with him. You know, the bite a bit or the gamekeeper turned poacher or whatever, and he said, yes, it's always difficult because you always see both sides of the case, and it depends on the remit that you're proceeding from, which side you come down, which is true in many professional walks of life. The other problem with, you're right, there are 2 methods of calculating the 5-year land supply. One is called the Liverpool method, and one is called the Sedgefield method. Sedgefield and Liverpool being local authorities that brought the cases. And we have, under the Sedgefield method in the Norwich policy area, the situation is much worse than it is under the Liverpool method. I think the difference is between 3.52 and 4.71 or something like that. It's that sort of a difference. And the point is, every planning inquiry, the barrister will argue for the one that favours his client's case, which is what is his professional duty. And the inspector is tending to come down in favour of the Liverpool one, which gives us a slightly closer margin to make good the deficiency. But the government, I do know, because one of our councillors is on a government working party that's looking at these sorts of issues, not me personally, but I do know the government is seriously considering whether they need to have a different approach to this. And this is where the CPRE as a national body needs to perhaps make representations at the highest level, because, you know, it's only in exceptional circumstances that I have any dealings whatsoever with anyone other than my local MP. I do happen to know, for historic reasons, 2 or 3 people who are quite high up in the government, but I have no immediate means of contacting them or putting pressure on them. But you do remember that in the county of Norfolk, you have a cabinet minister, you have 2 junior ministers, and you therefore those of you who live in South West Norfolk, you've got a cabinet minister. Those of you who live in Mid Norfolk or Great Yarmouth, you've got ministers. And indeed, the Minister for Housing is Brandon Lewis, who's the MP for Great Yarmouth. And those of you, if you have members in Great Yarmouth, they are in a much better position to pound on Brandon Lewis's door and ask him to deal with these issues. And that will be a door which I can tell you is not entirely bolted at the moment.
Well, it kind of follows on actually. You talked about lobbying earlier. Can you give some advice on an effective method of lobbying?
Well, you have to have a strong case, and you have to put your case forward succinctly. That's very important, because bear in mind that the people who have to deal with these things have a large volume of paperwork to deal with. If I was having a planning committee meeting tomorrow, DMC meeting tomorrow, I would have to set aside the whole of this evening, Tuesday evening, to reading the papers. I will have something like 140 pages. Now, because of my professional background and my academic interests, I can read 140 pages quite quickly, because you scan read, you look for the key word and then you expand from the key word to the bit around it. You don't have to read it from end to end of each paragraph. But not everybody has acquired that skill, and it's not a skill that can easily be taught. But you've got to bear in mind that people all have their own ways of looking at material, and if you can present your case in a page and a half, it's much better than presenting your case in 10 pages. And that is, I think, one of the key points, is to engage people. I personally don't like bullet points, because I find it difficult to refer to the fourth bullet point. It's much easier to refer to paragraph number 4. So if you're making points, make them in a way that people can identify what you're talking about when you refer to them, when you refer to the document. But I think those are the... And do not be afraid of using semi-technical language. If there is a correct technical term that you're familiar with and you're confident that you're using correctly, use it. But don't guess that it might be the right word to use, because you could actually be saying the direct opposite of what you intend if you don't use the right word.
Okay, thank you. In the middle, and then we'll go to the back. And then I think our time is up.
Any thoughts about opportunistic development undermining the local plan?
Oh, that's cost trouble for all of us.
That happens in Cringleford.
Well, it's happening everywhere. And it's not a ground for refusal. And the fact that the man is an unprincipled speculator is a point that I might well make on the political soapbox, but it's not a point that I can make in the planning committee, where I've got to act quasi-judicially.
You mentioned earlier about judicial reviews.
Yes.
There was one recently that was passed saying that the local plan must be given a chance.
Yes, that's right. That's the sort of point that our colleague from the Prince's Trust was making. There is a movement towards trying to hold... You see, we cannot refuse an application because it's premature, for example, but there are ways of achieving the same result by a different form of wording. So it's never a good idea to object saying this is a speculative application, but you can make the point that it is speculative in a rather more subtle way.
I'd advocate a plan-led approach.
Yes, that sort of thing, or this is a piecemeal development, but we want a holistic approach. Those are the sort of words that go down well these days.
Just a quick question, really. I'm sure
whatever they mean.
I'm sure our standalone, very small village community would love to have a neighbourhood plan, but how does a village of less than 500 population afford, or what do you say it's going to cost to do? Answers, please.
BIMBY's free.
BIMBY's free, yeah.
So have a look at the BIMBY online toolkit. There are lots of ways. The misnomer is that you have to cram lots and lots of things in there.
But it doesn't have the legal form.
It absolutely does. The fact is that neighbourhood plans have become really unstuck, where people have tried to overcomplicate them.
Yes.
As has been said before, it has to conform with the NPPF, it has to conform with the local plan, but and it also has to be conform with EU law, not that I assume you broke it in any way, shape or form. If you, as long as you stand by all those various different things, you have the ability to go and enable a plan right now. We suggest that actually it's a lot simpler than people have made out. And actually, there are a lot of consultants out there, not wanting to besmirch them, that have become very wealthy by, again, repeating the vernacular that it's very, very difficult to understand and you can't engage in planning because you don't understand the language. Well, actually, follow the BIMBY Toolkit, follow the 3 different workshops.
Okay, thank you. Now, I have missed the lady, and I'm not...
Just a quick question. I wondered if you've got any specific advice in relation to exception sites for affordable housing developments. At the moment it's been designated as an exception site. It seems to be very heavily weighted against...
Exception sites are in areas where the development is outside the development envelope for the villager or settlement in question, where there has been a survey, or there should be a survey, showing that there is a demonstrable need for affordable housing in the vicinity, and the land is going to be for affordable housing in perpetuity. Now that, of course, is an interesting concept in itself, because by law in perpetuity means 80 years. But in fact they actually want more than 80 years, and I'm not quite sure how you can secure that given the present state of the law, but that is a lawyer's point rather than a planner's point. You need to look carefully at how, somebody was asking me about this during the interval, how up to date the survey is, because sometimes the survey is several years out of date. In my experience, nearly every affordable exception site that there has been in South Norfolk has not been filled by people from the survey.
No.
They have had to cascade outwards, and this causes quite a lot of local concern. I think that the starting point is the survey. And I think that is the point where you have to get the survey right. You have to show that there is it's a local needs affordable housing. Local needs is at least definable. Affordable is not quite how long is a piece of string, but how long is a piece of string that's either 2 foot or 1 metre long.
So we need to get the council to...
You need to get the survey.
Well, perhaps you can carry on this conversation after, because I'd just like to thank our speakers. Chris was trained to catch 5. So Chris Weatherburn, Councillor Kemp, David Hook, can we just show our appreciation?